Hello, and welcome to my series on mock trial. Today, we're going to talk about a really basic cross examination. Cross examinations are different from direct examinations. The key to understanding this is to understand the roles. In a direct examination, you and the witness are on the same team. Cross examination, the roles are reversed. You are now questioning somebody who is on the opposite side. You're questioning somebody who wants to prove the opposite of what you wish to prove. And crucially, you're cross examining someone who has not had an opportunity to practice the questions with you. This is not an opportunity to ask complicated questions. Cross examination questions need to be very, very clear and very, very straightforward. This is your opportunity to ask leading questions. You cannot ask leading questions during direct examination, but you can and should during cross examination. What are some examples of leading questions? Here are some sentence stems that are very easy to use. I tend to use either "isn't it true that" or "wouldn't you agree that." In cross examination, you're simply trying to get the witness to agree with you on a series of statements. However, it's also an opportunity for you to simply plant ideas in the jury's mind. Sometimes it doesn't really matter what the witness answers. What matters is that the jury has heard the question. So there's an element of style to cross examination as well. The key here, though, is strategy. It's not necessarily what you say, but how you don't say it. Think about sometimes when someone is being evasive. When we think someone is being evasive, they're not answering the questions. So sometimes the witness not answering the questions can actually be a good thing. We want the witness to appear evasive. We want the witness to lose credibility. Let's take a look at a few basic examples as to how this might work. So here's a very simple scenario. It's a theft case. We have a scenario in which a young woman is alleged to have stolen a small amount. And the question is, how would we turn this around if we were cross examining? Now, in this case, let's imagine that we're the prosecutor. We're trying to convict the defendant of the crime of theft. And so, what we're doing right now is we're pretending that we are cross examining the witness. Well, what do we need to prove? Well, we need to prove that she took an item from the store, and we need to prove that she didn't pay for the item. That's it. It's not a complicated case. If I was questioning this witness, first, we, of course, as always, want to ground our jury in our time and our place. We would simply start out by asking, isn't it true that you were at Walmart on January 15th, 2004 at approximately 7:03 p.m.? The witness has no choice. They must answer that question, yes. Now, we want to make sure that we box the witness in. Could ask, isn't it true that you attempted to leave Walmart with several items in your purse? Again, based off of the previous report, the witness has no choice but to answer yes to this question. And finally, isn't it true that you did not pay for those items? Again, the witness has no choice and must answer in the affirmative. We have effectively, in 3 questions, proven our entire case. But let's flip that on its head for the moment. Let's pretend it's the exact same scenario. But this time, we're not the prosecutor. This time, we're the defense attorney. And in this situation, we're not so much focusing on what happened in the police report, but we're focusing on what didn't happen. Specifically, we want to draw the attention of the jury to some things that the officer didn't do. Now, we could do that very simply by asking the officer, isn't it true the defendant never told you she stole any items? They would have to answer yes. Now, isn't it true that you never asked the defendant, see how we use the negative, if the items were in her purse by mistake? We're stretching the truth a little while here because the witness refused to answer these questions when she was stopped. That being said, we're not trying to prove anything here. We're trying to disprove something. And the way that we do that is by slowly poking holes in the prosecution's case. You might also ask, isn't it possible that the defendant picked up the items by mistake and forgot to pay for them? Of course, the witness would probably say something like, well, I think anything's possible. Do not let them off the hook in that case. You must repeat the question and ask them again, isn't this thing possible? I didn't ask you if anything was possible. I asked you if this was possible. Once more, it's what you're saying that matters, and not so much the witness. The witness is not going to admit that they planted evidence. There's not going to be some grand Hollywood moment. But what you can do is chip, chip, chip away. And you do it by asking leading questions and focusing on the gaps in any sort of report that you receive. Remember, not all defenses can be perfect. Not every case is perfectly defensible. You are there to provide competent and effective representation. And that is the constitutional requirement that we go with. But not every defendant can be defended, just like not every case can be prosecuted. Not all cases are equal. You must do your best.